implementation of judgments of the European Court of Human Rights. My name's George Stafford. I'm co-director of the European Implementation Network, and I will be moderating today's webinar, along with Anne Speck, who is EIN's other co-director. Our colleague Agnes Sigaron is also online with us, and we welcome her. So the three of us form EIN's Secretariat. We're here to support civil society actors from all across Europe in their work towards the implementation of judgments. But today in particular, we're here to introduce three different speakers on the subject of how to advocate most effectively for the implementation of judgments of the European Court of Human Rights at the domestic level. Our first speaker will be EIN Chair and founding member Başak Çali, Professor Başak Çali, I should say, alongside two of our partners. Firstly, there'll be Kirill Koroteyev, Head of International Practice at the Agora International Human Rights Group in Moscow. And second, there'll be Teodora Ion Rotaru. Apologies, Teodora, if I've got your surname pronunciation wrong, but I'm sure you'll correct me soon. Who's the Executive Director of the Romanian Lgbti rights group at CHEPT. So before we introduce our speakers, there's just one or two housekeeping matters to get sorted. Today's seminar will last 1 hour, including a Q&A, and we'll take questions and answers after each of the speakers give their presentation. At the moment, all of the dial-in participants, apart from the panelists, who I've already mentioned, are muted. So it's quite natural that we can't see or hear you at the moment, and that's just a webinar function of Zoom that we're using that allows us to control quite clearly who's speaking, who's not, so we can use the time we've got most effectively. However, as I really hope that you'll come in with your questions. Please don't use the chat function, but actually try and use the Q&A function, and that you'll be able to see that at the bottom of your screen. So put your question there, and then one of the moderators will then present that to the people who are speaking, the panelists. We'll also, if we have time, try and bring in some people over the video function. Finally, it's also important to note that we're recording today's session in full, and that recording will be available online on EIN's website. So we really do encourage you to go ahead and share that recording or watch it again, however you want to use it. That's for the purpose for it to reach as many people as possible. But for now, that's enough from me, and I'll pass over to my colleague Anne Speck, who will do more introductions for today's topic.
Thank you so much, George, and hi everyone from my side as well. Let me start by echoing George's welcome to you all to this Zoom meeting, which marks very excitedly the launch of a brand new EIN toolkit, a guide for civil society on how to use advocacy avenues at the domestic level to promote the effective implementation of judgments of the European Court of Human Rights. It's now available on our website, so please go online, download it, share it, read it, and provide feedback. When EIN was set up 4 years ago, its main aim was basically to give civil society a platform for advocacy in Strasbourg. And we've actually seen very good results of our collective efforts to ensure civil society voices are heard in Strasbourg. Last year, for instance, NGOs made a record number of written submissions to the Committee of Ministers on cases awaiting implementation. But we also know that real impact is only achieved domestically. Once the judges in Strasbourg hand down their judgment, the case returns to where it started, essentially, the national level. And it's here that the authorities must ensure that judgments actually lead to justice. And civil society can and should play a key role in making this a reality. Now, against this backdrop, it was quite striking that we actually knew very little about what strategies and tools NGOs were using to push their cases forward domestically. So we set out to find out, basically. The guide we're launching today is the culmination of several months of research during which we tapped into the collective knowledge of our network. We launched a questionnaire and analyzed responses received from roughly 20 NGOs from 16 Council of Europe's member states. We also had numerous meetings, phone calls, email exchanges with members and partners from across Europe who were kind enough to share their domestic advocacy success stories with us. But while the toolkit presents good practices that have led to progress in the implementation of cases, it does not claim to have all the answers. It does not tell you what to do, It does not contain an advocacy roadmap that guarantees successful implementation if you just follow certain steps. And it couldn't possibly do that because there are so many different factors that impact on whether or not implementation and implementation advocacy is successful. Who needs to take action to resolve the underlying issue, for instance? Or how well does the government coordinate the process? What financial and political implication does, or what financial and political costs does implementation entail? And does public opinion weigh in favor or against implementation? This means that conditions for implementation vary vastly across states, across time, but even from case to case. And frankly, the implementation process can also be a little unpredictable. It's not a linear process. It can actually be quite messy, if I may say so. But the good news is that you can come to grips with this messiness. And today we'll hear from two speakers, Theo and Kirill, who have found very creative ways to work around the messiness and make real progress even in difficult circumstances. And their experiences are just two of many that show that even where the cards might seem to be stacked against implementation, there might just be this tiny window of opportunity that you can use to bring about positive change. But before I throw over to Kirill and Theo, I give the floor to EIN Chair, Professor of International Law and Director of the Center for Fundamental Rights at Hertie School of Governance in Berlin, Professor Başak Çağlı, to talk us through some of the main lessons learned that are presented in our toolkit. So Başak, please, you have the floor.
Thank you. Thank you very much, Anne and George. Also, thank you for bringing all of us together. I see in the chat function, people are saying that we were not able to see everyone's faces. George was explaining this is because we're on a panel kind of mode, and we see the panelists, we can see each other, but we won't be able to see you. But we're looking forward to hearing from you and seeing you if you'd like to raise hands and take the floor after some of these discussions that we're having today. I'm really delighted to be on this first webinar of the European Implementation Network. Some of you would know that we were actually planning to be all together in Budapest yesterday and today. We were supposed to be having our network meeting and to talk about these experiences of how we do domestic advocacy. But of course, we're all in our homes and subject to a lot of public health restrictions. So we thought that this webinar would be a good way to start a conversation and to start some of the discussions on what we learned. I'm going to share my screen. I have a couple of slides. I read this great report in the past week. I read it again yesterday. So what I'd like to do is to give you a bit of a sense of what are the things in the report, why you should read this report, and why you should really give us more feedback and ask us a lot of questions about how to use this report and how to also improve it. So let me share my screen for a second, if you bear with me. Here it is. Here is the report. We call this a European Implementation Network Guide for Civil Society. As Anne also mentioned, this is not sort of a solution to how these judgments will get implemented, but it actually gives us a lot of ideas about the collective thinking. A lot of people across Europe in many NGOs, legal and non-legal, have been thinking about domestic advocacy for some time. And the aim of the report is to bring all these collective or individual action in different parts of Europe together so that we can actually hear each other, which is something very difficult to do if we're not spending a lot of time together as a network. So there's lots of conversation in the report. A very, very big issue, why we wanted to focus on domestic advocacy. I think as EIN, we are currently, as a network, we're very proud of our international advocacy. We have made quite a lot of Rule 9.2 submissions as civil society or as lawyers, Rule 9.1 submissions over the years. These numbers are rising, but of course the implementation record is not necessarily improving. There are still over 5,000 judgments that have not been effectively and fully implemented, and about 43% of these judgments engage systematic or structural problems, as the research of EIN has documented in January 2020. So there's a lot more work to do for organizations like EIN and its members to do more effective domestic advocacy and to combine it with the international advocacy that has been done at the level of Council of Europe. So the report is based on quite a lot of conversations that our organization have had with a lot of NGOs, a lot of lawyers, a lot of practitioners. And these are some of the key points that have come in all these conversations. 4 major takeaway points I think that we've identified. The question is it really 4? Are there more takeaway points? What other feedback you could offer the network to improve this thinking? The first, what we found from our survey of discussions is that for domestic advocacy to be effective, there has to be a strategy. The second one is that we have to engage with the authorities. We have to find ways of engaging with authorities for advocacy. The third one is coalition building. Coordination and more coalition building is absolutely essential. We have to amplify and multiply our work by working with others. This has come through very consistently. And the fourth one is how important it is, and it is to actually have effective communication strategies about judgments. As you see, all of these things are not lawyers' jobs or not the strongest points of lawyers. And clearly, litigation is very important, but of course, as we have always said at EIN, just litigating a successful case oftentimes has absolutely no meaning. So this is something that we have to, I think, continuously come back to as a group of organizations, lawyers or non-lawyers, in thinking through these issues. This is one of my favorite quotes, and this is from Dr. Kane from Krasimir, who is an EIN board member and also a member of the network from the Helsinki Committee in Bulgaria. And of course, he says something quite obvious that when a judgment is there, when a case is won, one has to have a plan about how to effectively advocate for it. How to effectively advocate for it clearly cannot be ad hoc or one-off or writing one letter and sort of giving up or getting frustrated about it. And Krasimir says, well, you have to have a plan, and the plan has to have very important components. One, of course, is walking backwards from a judgment to implementation. So we have to read the judgment in a completely different way to actually figure out what we have to do to actually get it effectively implemented. This is something that I think we all do in an excellent quality in many parts of Europe in multiple jurisdictions. But of course, what needs to happen is a different thing than how to make it happen. So which actors to work with in order to get these results. And the mapping of actors, both the willing and the unwilling actors, seems to be an incredibly important part of the exercise. And of course, then there are the questions of lobbying, coalition building, advocacy, who to talk to, who to involve, who not to involve. There are lots of strategic questions that has to be made. My really big takeaway points from both the experience of Krasimir and lots of others that come up in the report is that one has to have a strategy. The strategy has to be realistic. The strategy has to be a long-term strategy, so not giving up after 6 months or 1 year or 2 years on these issues. And of course, the strategy has to start pretty early, probably even when the case is being litigated, the most ideal strategy, but of course, that's not always possible. We have a lot of discussion in the report, and I will be very keen to get feedback from you about how you discuss and think through these strategies and who is involved in actually devising strategies. very, very crucial. Effective engagements, it's a big issue in many jurisdictions. There's no one to engage because there are not that many willing actors in some countries. Not every domestic authority is waiting to engage with lawyers or civil society organizations. But what we found in this report is that there is always one or two actors, even in the most difficult circumstances. So I think the engagement question has to really find those willing actors and not just make a list of all the unwilling actors. And this seems to be a very crucial strategy that people employed in very different places. We have quite a lot of examples. This is from the Georgian Young Lawyers Association about how to engage parliaments. And of course, this depends from case to case. We have some very important examples of how to work on specific cases, because a specific case may map out some willing actors and unwilling actors in different ways, because strategies have to change from case to case. Here we have this very interesting model from Lithuania, from the Human Rights Monitoring Institution, where they actually make something like a Rule 92 submission, but to the government authorities instead of not to the Council of Europe authorities, and having working with some of the agents there. And a very important, a different type of advocacy that we've identified in the study is actually not making advocacy for judgments themselves, but actually doing advocacy for building institutions in order to enable advocacy for judgments. So sort of working on advocacy for strengthening the offices of the government agents or the parliamentary monitoring bodies, for example. This has been highlighted by the Legal Resources Center in Moldova. Effective engagement with authorities is a nice mantra, and you can say, well, it's not easy, it's very difficult, there are lots of unwilling or unable authorities at stake, but one of the things that the report really highlights is how people find those authorities, where there might be some pockets of interest in the cases and how to find and search for them. And this has come up very repetitively in the study that we carried out. This, for me, is one of the most important aspects. The third aspect is about the civil society alliances and coalitions, and by which we mean something really broad, because we've seen a lot of different models of coalition and alliance building around judgments. A judgment is not about one applicant, one lawyer, and one civil society organization. Quite a lot of human rights judgments actually concern much broader constituencies. And the question is how to engage others and build coalitions. The Open Society Foundation in Armenia, for example, has recently decided to set up an implementation platform, which will be a group of NGOs who would collectively think and strategize about these issues, which is obviously a model of actually building a domestic network, a domestic advocacy network for judgments. The examples from the Helsinki Foundation for Human Rights in Warsaw in Poland, with working with bar associations, is something that I found very inspiring. They said that how this really doubled their forces and voices in their advocacy. Of course, working with coalitions of lawyers and universities is something that was highlighted from our members in Ireland. And civil society is not just about other NGOs, but the Legal Resource Center in Moldova has also highlighted how they cooperate very closely with journalists and how they feed information on cases to them. So there are lots of different models out there that some of you may have used, or some of you may have used more or less. There's lots of food for thought in the guide, and we're really looking forward to hearing more from you about what alliances, what coalitions you have built in your domestic advocacy work. Communications. This is something that has becoming a lot more of a very prominent issue for EIN's own work as well. Especially, we're trying to have this communications drive, as you know, giving you a lot more understandable, usable information on the cases and the statistically, and also in terms of the humans behind them. And we've heard quite a lot from our members about how to use communications, both the more traditional media and also social media, about cases. A couple of strategies I think were very interesting. One is to emphasize the human stories in the cases and actually get the journalists and other media to be interested. They may not be interested in a very dry legal case, but of course people are a lot more interested in the stories of real persons. We also heard some very interesting examples about how the Rule 9.2 submissions that are made at the level of Council of Europe are used as communication strategies domestically. And the sort of the feeding of the domestic and the international advocacy. Again, a lot of food for thought. I hope that I'm really sort of whetting your appetite to read this report and to give more input into it so we can have more and more information about these experiences across our pan-European space. The very end of the report has what Anne Speck actually drafted is a checklist. This is something that I also value, because obviously it doesn't say how to do things in a particular case, in a particular jurisdiction, but it actually gives you a list of questions about how to build a strategy, how to engage with authorities, how to work with other groups and coalitions, and what kind of communication strategies you may use. Again, we really look forward to your feedback and your thoughts about how you do it, whether we should add more information in this report. And of course, we're really looking forward to your feedback on the report. Thank you. I look forward to comments and questions from you. And I'll just stop sharing my screen at this point.
Great, okay. Thanks very much indeed, Başak. And I think because now we have a slight issue with time, what I'm going to do is move straight on to the next speaker, which is Kirill. And I'm hoping to bring Kirill in now. Başak's already talked a little bit about why it's so important to carry out public communications work. And that's one of the reasons why we wanted Kirill to speak. There's two really important reasons, I would say, why Kirill's example is particularly notable. And the first of those is that some of the communications and media work that he did on one of the cases he's worked on has made a real difference, and you can see a direct link between the media coverage and the implementation of a particular case, and that's in the form of a constitutional court judgment. So it's obviously very important and very notable when we see work resulting in real impact. But the second reason, I think, is because Kirill's frame for engaging with the media is very interesting. It's really interesting to think about how he understood what was interesting to media actors and how they would become engaged in the work that he was doing. So that's another key reason. And finally, of course, the case concerns implementation in Russia, not the easiest place in the world for things to get implemented. So it's another powerful example for that reason. But without further ado, I'll hand over to you, Kirill.
Thank you, and good afternoon, good morning. You won't see my face for too long because I also share a screen. That's because I think, well, Russian surnames are not very easy to pronounce, so you'll probably see some names and pictures as I speak. And while I'm starting the screen sharing, I just want to say that, I've been doing ECtHR cases for just under 20 years now, and again, Committee of Ministers, as we learned from experience, is definitely not the best place to have your judgment executed, because execution definitely happens domestically, and that's where problems for Russia start, because there are not so many ways of democratic or rule of law based engagement. And Russian cases are hardly executed. You must have heard about Russian laws and Russian constitutional court judgments saying that, Russian authorities may decide not to execute European Court of Human Rights judgment themselves. And probably things that not make international headlines is that Supreme Court also declines to reopen criminal cases, and more and more often. So it started with Hizb-ut-Tahrir, then Yukos-related cases, now Bolotnaya Square protest cases, where European Court of Human Rights finds a violation, and then Supreme Court confirms the conviction. So, however, in some, I would say, probably exceptional but not unique cases, some ways of executions were possible, and that was where, I mean, the submissions to the Committee of Ministers played only a marginal role, and sometimes didn't play any role at all. But I will focus on the case that concerned indefinite detention of stateless person pending expulsion. Well, because no state is under an obligation to expel a stateless person, expulsion cannot be effected, but people still were detained for up to 2 years, and despite expulsion not being possible, well, European Court of Human Rights obviously found a violation of Article 5 in this respect, and also that's important on a minor matter, conditions of detention in the detention facilities for aliens. So I will focus on the Kim against Russia case, and that concerned Article 5 issue of detention pending impossible expulsion. And one further thing you need to know about Russian context is that there are at least 2 highly professional and well-regarded journalists in Russia who started covering constitutional court, but they also cover European Court of Human Rights related issues. And they worked at the time both at 2 business dailies, 2 leading Russian business dailies at the time. So you see Anastasia Kornia from Vedomosti and Anna Pushkarskaya from Kommersant. And they are not only well respected by the readership, they are also respected by the Constitutional Court, and there is ample evidence that Constitutional Court judges, Constitutional Court staff read what they write and take it seriously. I mean, if you are in Anna Pushkarskaya article, then it is for a reason. So back to the execution of Kim case. Well, several lawyers and NGOs working on migration issues dealt with subsequent cases where migrants were still detained, stateless persons, sorry, were still detained pending impossible expulsion. So there was a lot of practice to summarize, and the lawyers and NGOs came to Human Rights Center Memorial, where I was then working, and which had prior experience of Row 9 submissions, and asked for like putting it together in a submission, and we made a joint submission to the Committee of Ministers on the Russian authorities' failure to implement Kim. And we didn't really think it was, you know, something Business Daily's readership would be passionate about. So I was somewhat surprised that several weeks after submissions was made that I received a phone call from Anna Pushkarskaya, who said, and that's important, she said, "Oh, I was browsing the submissions on the Committee of Ministers website, and I see you made a submission. I want to make a story about it. And so she was like doing it of her own motion. I don't know any other journalist who would. She wrote an article, and it was a half of a third page of Kommersant, which was then one of the two leading Russian business dailies. And with stories and cases detailed, and then because of this previous litigation in general courts, there was an application to the Constitutional Court by Mr. Mshiladze, who was a stateless person, who was to be expelled. No one knows where, because no state had to accept him. The Constitutional Court, after Anna Pushkarskaya's article, really picked this case out of its docket and scheduled a hearing. And in April 2017, the hearing was held. And in May, like 5 weeks after, the Constitutional Court gave a judgment in the case of Mshiladze, where it said that the provisions of the Code of Administrative Offenses of the federal laws on the status of foreign nationals were contrary to the Constitution insofar they allowed for detention of stateless persons pending expulsion, because, well, expulsion cannot be effected and there is no constitutional ground to detain them. So that's how, and the Committee of Ministers, yes, I received 2 calls, I forgot. So the second call was from the Committee of Ministers. And the Committee of Ministers said, oh, look, there is an issue in your submissions which deals with conditions of detention. And it's true, there were like a couple of paragraphs on that. Can you please, make these 2 submissions separate? Because we have, Kim group of cases and we have Alim group of cases. So you have to have, Kim issues separately on detention and Article 3 on conditions of detention separately in Alim. That was something, that shows how, the Committee of Ministers treated the submissions and how Russian business press treated the submissions. So it speaks definitely in favor of people like Anna Pushkarskaya. There were other cases executed like this, sometimes with, sometimes without submissions or to the Committee of Ministers. And there was scrutiny on expulsion of HIV-positive aliens. Agora, where I now work, did this case again. It required overruling previous Constitutional Court case law. There were no submissions to the Committee of Ministers, but again, with the support of the journalists, it worked because, again, Constitutional Court felt it has to do something with the applications raising a matter important enough for press to cover. There was Shtukaturov on procedures for stripping mentally disabled persons of legal capacity. There is now Polakova, where, again, thanks to wide coverage in the media of the matter, the judgment on sending prisoners to serve their sentences far from home results in not totally satisfactory, but still in considerable tangible legislative reform. So these were also possible without Committee of Ministers submissions, and the case we've been working on is Berkovich concerning the right to leave Russia for those who have access to state secrets or are in law enforcement. because like the rank and file policeman cannot leave Russia even for you know, a mundane trip to visit family members or spend some time on the beach. There is 2006 judgment where it all started. 10 years later, European Court of Human Rights in Berkovich gave Article 46 judgment saying people cannot leave Russia, and there is a constitutional court submission, and this time there was Vedomosti on our side, another business daily, a police ombudsman blog, which is very influential in the police sphere, and its author is now in prison for that, and also private lawyer. I mean, lawyers with who specialize in civil law, but you know sometimes discover issues from public law, but they have again a lot of readership among business lawyers. So this is yet to produce any result, but we still have a vibrant debate on these matters here. And when we made these submissions and they were covered by Vedomosti, I received a phone call from Anastasia Kornia, Vedomosti journalist, and when I asked her whether she would cover the Committee of Ministers' decision after the submissions, she told me she didn't care what the Committee of Ministers would decide because it would be late, obscure, and irrelevant. What she was interested in is that there was a debate between part of Russian civil society and the government, and that civil society was demanding, you know, something they think was important. So moving to the conclusions, because I'm almost already well past my allocated time. The submissions may be a document to debate internally in your community, in your country, depending on the matter. And it is important that they are defined by your agenda, not by the Committee of Ministers' agenda. Berkovich coincided somehow with the Committee of Ministers' agenda, but Kim did not. Definitely, we never cared about what's on the Committee of Ministers' agenda, but we believed it was the right thing to raise. Again, it depends on the fact that there is professional journalists who, if not, you know, work for free media, then they are still free and so important that even a non-free media cannot fire them arbitrarily, and they are also respected by the judges. That was important in the cases of Anastasia Kornia and Anna Pushkarskaya. So professional support with social media, with debate in the press, may lead to positive changes, and there is a report by my colleague Dmitry Kolbasin. So I think it's only in Russian, so Russian readers may access a wider, you know, a description of how in a non-democratic society, which Russia unfortunately is, but not totally closed yet, civil society, through pressure by the press, by social media, by professional support, may force the government to bring about the change. So I highly recommend his Agora report. And last line, if you don't win against the government, you still win your fellow citizens' opinion, and that is important because I think, well, it's highly important that, you know, we work not for not only for good abstract causes, but to, you know, to be helpful to our fellow citizens to exercise their rights. So if we can contribute to that, it's, I think a huge advancement.
Kirill, thank you so much for that. That's much hugely appreciated. I was just wondering, we don't have too much time for questions because we're overrunning a little bit and we want to bring in Theodora, but if there is maybe one question that we can put to Kirill, that would be fantastic. If anyone wants to put something in the chat function, the Q&A function, we can all raise your hand. Okay, not sure we're getting any questions through, but that's quite convenient in terms of our timing. So perhaps what I'll do is I'll just hand over to my colleague Anne Speck, who will introduce our next speaker.
Sure, thanks, George. And if while Theodora is talking, you remember that you wanted to put a very interesting question to Kirill, please feel free to use the Q&A function and do so. But now we move on to our final speaker for today, Theodora Ioan-Rotaru. She's the Executive Director of the Romanian LGBTI rights organization ECtHR, which has been pursuing a really ambitious and interesting and also comprehensive advocacy agenda around a case concerning hate crimes against members of the LGBTI community. Now, Romania has a much better overall implementation record than Russia, but this is a good example of a case that, because of its political salience, makes implementation really difficult. The LGBTI community in Romania is facing a lot of prejudice, a lot of discrimination, and we will hear from Theodora how they have tried to navigate these difficulties, how they have sought to change attitudes that stand in the way of implementation. And these attitudes prevail not just in the general public, but also among the authorities. So without further ado, I'd throw over to Theodora to take us through her case example. Theodora, you have the floor.
Thank you, Anne, and thank you for your kind invitation to speak today. I'm very happy to see a large group of participants, and I hope that our experience with domestic advocacy is going to help other organizations to put together a comprehensive advocacy agenda. I want to start from a point that's really important in understanding the context in many Eastern European countries that, despite their communist past, have joined the EU, and mentality-wise, practice-wise, policy-wise, are still in between real respect for human rights and following the European agenda and dealing with their baggage from 30, 40 years ago. And when it comes to LGBT rights, this is specifically important and specifically relevant. There's this concept called shallow Europeanization, and it's something that we need to take into account, especially since I see many of the attendees are part of organizations probably who are from across the region, right? The newer member state or the ones who are looking to join the EU eventually. And it's really important for us to understand that shallow Europeanization means that authorities, despite having, to fulfill certain accession criteria before actually joining the EU, don't change their mentality, their practice, the way they behave towards human rights in general and towards minority groups such as the LGBT community. And what we have seen trying to implement a decision concerning a hate crime case against an LGBT, against 6 LGBT individuals, has faced the same prejudice as it would have maybe 30 or maybe even 40 years ago. I'm gonna share my screen to just make sure that you can see a couple of important ideas that we've put together for today. Just give me a sec to navigate this software. Okay, so basically MCNAC concerns a case that happened at Bucharest Pride back in 2006. I'm just going to play a short video trying to show you just a couple of minutes of how it was like to attend Pride back then. So basically, the images that you've just seen are taken just a year before the Romania joining the EU, and they were the scene of the heaviest violence against Pride that we have encountered as an organization. And following attending the march, 6 young men and women decided to leave by the subway, where they were stopped by a group of 6 other people, 6 aggressors, who severely beat them up. The problem remains, the fact that when trying to get the assistance of police and have an effective investigation conducted for the incident that just happened to them, they were basically stonewalled. Instead of receiving help and having the treatment that everybody should get, when addressing a complaint to the police, the 6 young men and women simply were refused, were discouraged to file the complaint, were threatened that they would have to face their aggressors. And the police did not ask for surveillance video. The police did not call in witnesses despite having their name, ID, home address, because they were identified as very vocal protester on the side of the march. The first witness to the case was called 2 years in the investigation, So with all those procedural problems, the European Court of Human Rights judgment we got in the case following 10 years in court, in national and European court, basically said that Romanian authorities are as bad as the aggressors when they're trying to cover up for this type of situations and not do their proper job in an effective investigation. As a result, and I'm going to move through the slides a bit faster since I'm aware of the time, we try to initiate conversations with the Department of Execution of Judgments and with the Romanian governmental agent, who are authorities that should work with civil society in terms of monitoring the implementation on behalf of the national state, and the governmental agent to try to coordinate the national plan of action for implementing measures to prevent future human rights violations from happening, but also to try to interact with civil society. As part of the general measures in the implementation process of the case, we felt, and the governmental agent agreed, that data collection and monitoring hate crime is very important, that police training is also very important, hate crime investigation methodology is something that's needed to be developed in Romania, and also proactive measures to enhance the level of reporting and to build trust within the LGBT community, but also the way police is interacting with the community to be improved. All these measures are not implemented even to this day, despite the decision having been issued in 2016. And there are a couple of issues that stand out in the implementation, especially in terms of us trying to raise the topic higher on the agenda regarding the monitoring activity of the Committee of Ministers. We need to understand that Romania is a country that faces a lot of judgments and has a full agenda regarding implementation. There are more than a couple hundred cases in implementation, and over 50 of them are on enhanced supervision. And our immediate goal was to try to get there with the implementation activity, while also convincing Romanian authorities to treat LGBTI people better and act on their behalf in improving policies and practices at the level of authorities. And while we were in this process, we viewed and studied a couple of barriers in implementation, such as the entrenched view of police authorities, of prosecutors, of all those who were around the table in the implementation conversations, that hate crime was really not a phenomenon in Romania. Because they did not collect data, they thought that the 7 hate crimes they report to international authorities are actually what exists in practice and reality. They also have a lot of egos in hierarchical institutions that don't necessarily work well together, meaning police, prosecutors, etc. And they really think they know best, right? So we had to try to put them in front of cases of real people who have went through this type of cases. And even if for us it really seemed like a no-brainer, it's something that they have never experienced before, despite being involved in so many implementation frameworks with different other organizations in Romania, or not. Basically what we tried to do was to get victims of hate crime, especially those who were part of the initial case, to speak at the roundtables we had with authorities to make the situations more real for them. We as human rights activists tend to, maybe not understand every single time that authorities don't have the same experience. And we tend to be very explanatory in our interventions, try to frame very politely situations, but sometimes having that raw input from a person who experienced the interaction with authorities is something very valuable, and it helps them, those sitting around the table, to understand what the role is, to really understand that if they're not doing their job, people are going to suffer and people are going to die. And it's something that often they don't get. And having this type of interactions in order to bridge the gap between sitting all day in an office and trying to be proactive in your measures to reform a process, to reform a system like the one focused on reporting and tackling hate crime is something very important for us, and it became important for them. However, we also found that there are other ways to raise awareness and be more cohesive in how you interact with the implementation process. During the meetings that we had, we relied a lot on the interaction with two governmental agents. By the way, this might not be the case of many other countries across Europe, but since we've started implementing this decision in 2016, we had to deal with 4 different agents who have been quite often removed from their position in light of political reasons, not necessarily competence reason most of the time. And with the first governmental agent, we had a very good interaction, and she really took the case as an important one on the departmental agenda. And the process has really started lagging after her removal. We also had professional expertise around the table. I myself, I'm not a lawyer. However, I'm a human rights activist, and I have the role to put together resources for the LGBT community in Romania, while also making sure that we do community building, community development, public events communications, right? So you always need to have people working together to implement a decision that also focus on the legal issues, but also on the community issues and the communications issues. All these things need to go together in order to raise awareness at the level of authorities and of society regarding your implementation. We also had institutional allies around the table. And in our cases, the National Equality Body, that's part of ECtHR, and it's called the National Council for Combating Discrimination. They have been basically the only public institution that cohesively and consistently stood up for LGBTI equality in Romania. And it's very important to also try to work together with other organizations that implement decisions around the same topics. So there are, for example, many decisions that focus on the police inability to really look at different minority groups and interact with them and solve their issues and not abuse them. So what is very important for us is to work with organizations that have cases focused around the police abuse or police violence or the lack of engagement with domestic violence cases or the lack of ability to properly investigate sexual violence, for instance. And many of those decisions are really caused by the fact that police has no human rights training, has no capacity to interact with victims of violence, has not developed an understanding and a relationship with minority communities that would make them trust police and really bring their cases and their issues with them. And what we have been consistently doing in order to follow our own advice is to basically just try at least once a year to submit a report to the Department of Execution that evaluates how Romania has been doing in terms of implementing the initial plan of action it proposed. And to combat with data, with facts, with research, that some of the issues they present as big achievements to the Department of Ministers, to the Department of Executions, is actually not true and not right. And a very easy example is how much they've written on the fact that police get some training. And then we clarified how very few police officers in comparison with the total police force in Romania actually benefits from anti-discrimination training on LGBT issues. And the fact that we are the ones providing that training pro bono, right, to authorities, they don't have a program that's comprehensive in any way or not sustainable for us at least. We also try to involve through coalition building, other organizations. ECtHR is also the secretariat of a group of organizations that's called the Anti-Discrimination Coalition. And this is very important for us because hate crime is not something that's only affecting the LGBTI community, but all minority communities in Romania. So measures that are taken in the implementation process need to be relevant and accountable to other minority groups, not only to LGBT people. I also think it's very important that we don't settle, we don't necessarily agree with authorities when we know they're not right, and we don't consider tiny measures as being the ones that are necessary for solving the situation. It's very important to understand that when you have a European Court of Human Rights decision, you can play a bit hardball and do not agree that the measure that would maybe, plan to train 100 police officers is something that is enough. You need to ask for the maximum, you need to ask for sustainable measures, you need to ask for a plan that maybe spans 20 years, but it's going to solve the situation. And without foresight on behalf of authorities, human rights violations are going to happen again and again. It's also important that you keep reporting and you keep monitoring situations that have been included or addressed in that judgment, right? For us, it's hate crime. So we try to take on every complaint that comes to ECtHR, to document it comprehensively, to try to have all the information regarding what happened, to support the person, to file a new complaint to the police, to show that the phenomenon is not stopping, and to report to as many supranational or national bodies that count that type of incident in order to ensure that the data at least takes on, the official data at least takes on some of the cases that you have to deal with all of the time. We have had also great support from certain authorities and bodies such as the SOGI unit at the Council of Europe, who have been very good at trying to support exchange of best practices, trying to get resources for domestic implementation, call on authorities to do something more, so try to use all your links and all your resources in order to put this on the agenda. We have not done so much communication around this topic because there are many issues, affecting Romanian people, and the ineffectiveness of police here in Romania is something that's very notorious, and the image of police is already very bad. Shaming police even more, despite the fact that they deserve it most of the time, is not something that's very conductive of another thing that matters for us. It really matters that people report to police what happens to them. And we already are at a level of trust that's dismal in the context of EU data. The latest FRA survey really shows that only 4% of LGBT Romanians would go to police to report a hate crime compared to the EU average of 14%. Both numbers are ridiculously low, So this is something that's really bad, and it needs to be tackled very, very consciously, but by all states in Europe, I believe, in order to improve how LGBT people could seek protection when they need it most. We have assisted, for instance, people who, despite complaining to police time and again regarding the behavior, the violent behavior, the abuse of a neighbor, were never assisted. And in the end, they had to sell their apartment and to move somewhere else in order to make the harassment stop. They didn't want to sue police. They didn't think that that would solve their issue in a timely manner, and it was easier for them to flee. It's the same when LGBT people in Romania decide to simply leave the country because they've been told so many times that they belong in the Netherlands and not in Romania. But that doesn't mean that states don't have a real responsibility to tackle these issues. And it's our job as activists to make them understand at a very personal level. You know, every single person that works for that case implementation needs to know what we know, needs to understand and feel what we feel as activists. And then they're really going to do their job, because LGBT people and other minorities will not just be numbers on a piece of paper, but rather real people that have feelings like them. And we need to break this barrier of understanding between authorities and minorities. And I just want to show you a picture that was taken on the spot during the hate crime incident that was reported back in 2006. It was just as it happened, one of the people who attended Pride together with this group that was attacked, they had a camera back in 2006, and they were on the same subway, and they captured the moment right after the attack, with everybody being very scared and huddling up. The guy you see on the ground was also one of those who took most of the blows. And this is, you know, how Romanian police used to protect Pride back in 2006. And you can see here another picture of a line of police officers, but these are images from more recent years, and you can see people just walking freely in large crowds. And this is just, you know, 10 years later. We have not had incidents at Pride for some time. However, following the march itself, every year we still have people who are followed into the subway or in other means of transportations and attacked if they have rainbow symbols or somebody notices they're coming from Pride. What has changed after many years of police failures is that none of them want to report it anymore.
Thank you so much, Theodora, for this very comprehensive presentation. And I think you end on your second to last, your penultimate comment is a very important one, and it shows how, or you underscored the importance of showing what continued injustice means to the victims of human rights violations. And a number of the issues that you raised really correspond to what we've seen throughout the toolkit, from examples from all over Europe, the importance of finding the right people and the importance of, or the dependency on individuals of the implementation process. And at the same time, the windows of opportunity that you can create by making the decision makers listen to the political, to the victims and potential beneficiaries of reforms. So thank you very much indeed. We have had a number of questions come in for Kirill. So I would love to take those, and I know we're already 10 minutes over, but we still have almost 100 attendees, which we're absolutely thrilled about. So we would give everyone a chance to type their question to Theodora in the Q&A section now, and I would use this opportunity while you're thinking of questions to Theo to put a couple of questions to Kirill. The first is from Ekay Yakubishvili, who asks, what avenues exist in Russia that provide a platform for ECtHR related discussions, given the difficult relationship between Russia and the Council of Europe? Kirill, would you take that question?
I think I'm still muted. No, not anymore. Look, well, there are some formal procedures like reopening of criminal cases by the Supreme Court or reopening of civil cases by district courts, which do not often work, but again, there is a considerable room for public discussion on social media or on traditional media, because there are few that remain probably not independent but semi-independent. As we speak, we are losing the independence of Vedomosti, and that's a huge problem. We lost Anna Pushkarskaya in Kommersant. She's no longer there, which is a pity. But there is still, there are other internet media which generate public debate, like Mediazona, like Medusa, and that sometimes brings results. Again, not necessarily ECtHR related, but the results are, of course, tiny compared to the setbacks we suffer every now and then from the government. Yet it's not totally one way, and one thing you probably need to know is that Russian society is much more advanced, much more modern and democratic than the Russian government is, which is obsolete and again irrelevant on many of its policies.
Thank you, Kirill, for answering this question. There is another one from our member from the Netherlands, from Harry Hummel, who wonders whether the tactic that you described on getting media attention would also work, perhaps to a lesser extent, on North Caucasus cases, which presumably, he says, are politically extra sensitive.
Well, definitely not, because somehow, well, not that they are not covered by the press, they are. Here, I just need to go back to one of the first phrases I said. Please remember that what I was talking about is a highly exceptional successful case. The rule is non-execution, and again, North Caucasus cases are an example of that. There is no military serviceman who would be tried for crimes against civilians. And again, Supreme Court is only competent to review final criminal convictions. That happened in a couple of torture cases coming from North Caucasus, and in one of the cases, again, the defendant was sentenced to even lengthier sentence on the basis of his confession obtained under torture. So I understand his second application is now pending before the European Court of Human Rights. So North Caucasus is unfortunately the field where few things were achieved, if at all, but some were, not justice. A bit more knowledge about what happened, that's what we achieved. That's true.
Yeah, this again shows how how important it is for civil society to really adapt their implementation strategies to the particular case at hand, because the windows of opportunities that might present themselves in one case might very well be closed in another. There are two questions, one follow-up question from Harry Hummel and one from Inga Kravchik, that both go into a similar direction. So I'd like to take them together. Inga asks whether there is a possibility for civil society in Russia to find allies within the legal system itself, within the courts. And Harry asks if there is scope for more structural change in the Supreme Court by the Supreme Court taking up cases for revision after they have been subjected to an ECtHR judgment.
I think Russian judiciary has been carefully purified so that there is no judge who is, you know, happy to take judgment, who is happy to be an ally. sometimes they still have to decide cases under law, and that is the cases where judgments they produce may be in conformity with the convention and implement ECtHR judgments. But definitely it's not about alliances. It's again about how we defend our clients, how we pursue our agenda. So, and I don't want, to sound like, okay, we should work only on implementable cases. So if there is no window of opportunity in Northern Caucasus, this doesn't mean we don't have to work on those cases. We do, other NGOs do, and again, the results may not be the same in terms of implementation, but the issue is so important, we still have to continue working on it. Again, just to say that Supreme Court, I think I answered, but again, Supreme Court is definitely not the place which would, implement a ECtHR judgment because it so believes. I think the evidence goes to the contrary with, string of Bolotna Square cases especially. But on occasion, and even in politically sensitive cases, they may give judgments that are not totally contrary to the convention. They, for example, sent Navalny's case for retrial, but the retrial ended in the same conviction as the one found in violation of the ECtHR. So it's not, the judges are not independent, but the judgment may sometimes, go in different directions. And because we represent our clients, we have to go through all the available legal remedies in our system, however imperfect, however dependent it is on the executive.
Thanks so much, Kirill. That's really, really clear. And I'd just like to thank you again for this presentation. It's been really fantastic, and for all of our participants today. I'm having a bit of a technical problem. I'm not sure you can see me. So you can see me. Okay, fantastic. So at that stage, I think we'll just want to wrap up. That's absolutely fine. I don't see any questions for Theodora, so we'll bring the session to an end. Thanks so much for all of you for staying with us. As Anne said, we've had over 100 participants or attendees, so it's really great to see you all and for us to share this with you. Thanks to both our speakers, Kirill and Theodora, Bashak, of course, as well. It's hugely appreciated that you take the time. It's really fantastic for you to share your wisdom. The video of today's presentation will be online. Feel free to share that. Feel free to share also the Domestic Advocacy Toolkit text, which all my colleagues will now, I'm sure, share a link to in the chat function. So please do go ahead and look at that. It's full of loads more examples and loads more thinking about exactly how to advocate for judgments at the domestic level. It's very much a start of a conversation. We see advocating for domestic level strategies as something that's going to take a lot of work, because it's not something that's straightforward, it's not something that's the same in each country, and it's not something that we can come up to one day with an answer and then leave forever. So we do want to hear from you. Let us know what you think is working for you, what you think is wrong, or what you think is right in what we're doing, and we want to change it accordingly, and hopefully we'll be putting up an updated version at the end of this year. So it's very much the start of the conversation. Just perhaps a few more things to say about the way we communicate with you and the way we share these lessons for the rest of the year. This obviously is just a teaser for today. There's only a couple of speakers. What we really want to do is bring everyone together from the network, all of our members and partners, and have a big event that we had originally planned for this slot in May. Now, we would like to do that later in the year, and we are planning on the basis of hopefully being able to do it. also making, for obvious reasons, contingency plans to share some of these lessons over webinars. So we'll be doing a lot more thinking and communicating with you about how we do that online, if necessary. This is our first ever sort of webinar that we've carried out online. So thanks for bearing with us for technical issues or pauses, and we'll be sure to improve that as much as we can going forward. Very final thing I'm going to say is thank you very much to my colleague Anne Speck. Anne is leaving us today. It's her very final day of work at the European Implementation Network, because she's going off to pursue academia full-time. And she's been a really hardworking, insightful and passionate colleague. So I do encourage all of you who had interactions with her to send her a message and to let her know how much you appreciate her and how to continue your conversation after she leaves EIN. So that's it from me. We're going to conclude today. Thanks very much to you all, and we'll see you next time, and we will stay in touch. Goodbye.